Last month, one of our client has responded to a notice from Customs SIIB, rectified everything what they have asked for, and they thought it is done and dusted. Later, they have received another notice from Customs DRI. The client was in a panic and asked us, is this legally valid? Well, the Supreme Court of India, in the case of Canon India, in November 2024, has held that DRI is a proper officer for the purpose of the Customs Act, therefore they can independently investigate any matter. Therefore, the new reality is that a same shipment can trigger two notices, one from Customs SIIB and the other from the Customs DRI as well. If you are an exporter or a supply chain professional handling the customs matters for your company, hit that subscribe button and the bell icon. I will help you understand how do you handle such a situation when you receive notice from Customs SIIB and the DRI for the same matter. Here are the 5 things every importer should know. Firstly, what is the difference between SIIB and the DRI? SIIB is the Special Intelligence and Investigation Branch of the Customs, which sits in the Jurisdictional Customs Office, whereas DRI is the Directorate General of Revenue Intelligence, which sits in Delhi. While the jurisdiction of SIIB is limited to the customs port or airport, whereas the jurisdiction of DRI covers all over the country. Therefore, SIIB has a limited jurisdiction, whereas DRI has wide-ranging jurisdiction across the country. Number 2, what has changed after the Supreme Court judgment in the case of Canon India in November 2024? The Supreme Court has ruled that the DRI officers are the proper officers for the purpose of the Customs Act, meaning thereby they can issue show cause notice under section 28 of the Customs Act. Therefore, they do not need permission or need not to give an intimation to SIIB before issuing a notice. This reversed this previous Supreme Court ruling which held that DRI is not a proper officer for the purpose of section 28 of the Customs Act. Number 3, how do I deal with the multiple notices? 2 notices doesn't mean that you are allowed to pay customs duty twice. While SIIB may be investigating a classification issue, on the other hand, DRI may be investigating a valuation issue. Look at each notice separately and respond to them accordingly. More importantly, document all the correspondence with each of these authorities separately so that you can use it in future in your favor. Number 4, how do I deal with 2 notices for the same period and same matter, one from DRI and the other from SIIB? Respond to the other authority, say SIIB, stating that DRI has already investigated this matter for the same period and same matter, therefore do not investigate it further. Despite that, so in such a situation, what helps you the most is the documentation. Pull out all the documentation which you have already given to the SIIB, to the DRI. If they do not listen to that, despite giving all this documentation, you can consider approaching your jurisdictional high court through a writ petition. Number 5, documentation is everything in such a situation. So document everything, whatever you are communicating, whether to SIIB or DRI. If they ask you to submit some data on a particular date, either submit it by that date or seek extension wherever not possible. Sometimes if you do not respond to them, they deem that you are accepting their allegations. So therefore, document everything which can help you if you later choose to go to the High Court. This has happened to one of our clients. Tomorrow it may happen to you as well. If you have been facing parallel proceedings from different customs authorities, do drop in us an email so that we can get back to you with a detailed answer.